On mute. Okay. No problem. Oh. Hello, Dr. Oral.
Hello, hello. How are you?
Excellent. Yourself?
Good, good. All is in order.
I'm just sharing the screen for everyone so that when attendees start to join in, they'll have this screen here, okay?
Okay. All right. Great. Great. So, my friend, what time is it for you in Hanoi? I mean, it's late for me, 10:30, but for you.
Where are you located, Dr. Oral?
I'm in Istanbul, actually. So.
Oh, beautiful.
Yeah. So it's not too bad in terms of the time, but.
I love Istanbul.
Ambassador Nguyen, boy, it must be.
Yes. Okay, right.
There we go. Perfect. You're in now.
Perfect now.
I see David.
Oh, hi.
So, Michael, you've been to Istanbul.
Yes, I have. Yeah, I actually went to law school in England, and I went to law school in England and traveled a bunch. And yes, I love Istanbul. It's a great place.
Great.
Mm-hmm.
Yeah. Oh, lovely to see you, Niloufer. How are you?
Good, David. How are you?
Okay, so you're in Istanbul. Ambassador.
I'm in Istanbul till mid-December.
All right. Because when I said this time, I said, my godfather's that's 4:30 in the morning in Singapore.
Well, yes, but do you know Ambassador Nguyen from the International Law Commission?
Right.
Well, he's tuning in from Vietnam.
Oh, wow. Yeah.
Fine. Yeah.
Okay, not from.
Hello, from Vietnam, from Hanoi. Yeah. Good morning from Hanoi.
Right.
What time is it? 4:30?
Now it's 2 a.m.
Oh.
Yeah.
God.
Well, this is really great service.
Yeah.
Thank you so much for that.
This is true commitment.
Yeah.
So, so all is well, David?
Yes. Yeah. Been busy. Yeah, we're all locked down and, still getting a little fed up with it, but like everybody, but certainly we're a lot better off than a lot of people. So, and Rosa is getting more, that's my dog, more exercise than she's ever had for years.
That's great.
4 or 5 miles every day. It's good for me.
Fantastic. But she's keeping you fit.
That's right. I lost 10 pounds. So.
Oh, excellent. Good for you. Yeah.
Which is needed, so that's good. So Aimee-Jane's joining us then. Just a preliminary. I've got I'm going to use some slides which you've seen before as to kick off. So I wouldn't mind just practicing.
All right.
I don't know if I can do it from here.
So, but it's kind of kick off, but it's basically question and answer in 5 minutes.
Well, we have, if you look at the schedule that she suggested, she wants us to speak for a few minutes at the beginning, right? So what are the legal implications of physical changes to baseline? So that's my subject. So I've got 5 minutes. So I thought the best way to do this, because some of the audience are not going to be even law of the sea specialists, right? So would be to actually show the slides, so everybody like what law of the sea 101.
And what better professor to give law of the sea 101?
It's too kind. Well, you did a pretty bloody good job yourself, I'm sure.
It's true.
Shall I see if you can present? Let me see if
I have the questions. I know there were a couple though. Is that you on the archipelagic? It didn't say who was going to answer those. And the loss of. There were a couple of questions that didn't indicate who was answering them.
Oh, I see. I put them in my.
Oh, good. Okay, good. Okay, good. Perfect. Then. All right. Excellent. Okay. Very good.
So I mean, we've only got 5 minutes, so this is not,
I know. Oh, I say.
Oh, Jenny.
Yeah.
Nilufer.
Oh, is that Jenny? Hi, Jenny.
Hi.
Hi. How you doing?
Long time no see.
Hi.
This Ambassador from
Yeah.
it's calling from Hanoi, where it's 3 o'clock.
From Hanoi.
Wow.
Hi. Nice to see you.
Nice to see you.
You know, David and Hong. We were chatting with Patricia. You know Patricia, of course, from.
Tell us, yeah.
And she was, you know, it used to be we would stress out about, you know, making your flight or, you know, getting your tickets. And now, okay, where's my Zoom link? And what time zone am I in? And I said, it's so true.
The toughest one so far was the one we did for us was in Fiji, right? I mean,
yeah.
And the moderator overran by an hour. So, oh my God.
I know that was, and poor Bogdan, you know, I was in Singapore then, so it was okay. But for him, the time difference, he was already exhausted.
Yeah.
And by the time we talked, it was about 2 or 3 in the morning for him.
Yeah. And Subaidi, who's my former student, was on as well. Nicola. Nice. It must be early for you. Right.
Hello.
Late or early for you too.
Hello.
Hi, lovely to see you all.
Where is everybody based at the moment?
Well, I'm in DC.
Okay.
Istanbul.
Okay.
Wellington.
Oh, Wellington. Okay, so you're late as well.
Very early, actually. It's 8:20 in the morning.
Oh, yeah.
Okay, that's not bad.
Well, we all wish we
pretty
were in Wellington, I'm sure, because you've got such good controls of it. No wonder your prime minister got a landslide victory. I mean, that was absolutely amazing.
It's been incredible, actually, watching that result. It's the most incredible swing in, you know, recent election history.
Yeah.
Yeah.
Well, it's because it's personal handling of the COVID business, isn't it, really?
It is. It is. Yeah.
Aimee-Jane, so
yeah.
could I just have a shot at putting my slides up just to make sure that I can?
I think that would be an excellent idea, yes.
If I think you have to allow me, somebody has to allow me to do it because it says you can't screen share while the other participant is sharing.
So just one heads up. Right now, everyone's in the panel right now, and the attendees are in the room. So they can, if you would like, you can turn off your video and mute. They're just all joining in right now. It's totally up to you, or you can just sit on camera right now. I just have a welcome screen on the share screen right now, just for the attendees to just be looking at right now.
Is there so in other words, if I tried to share my screen, they'd see it as well, would they?
Correct.
Okay, all right. I've done enough practice for this for it to be fine.
Okay, no problem. Yeah. And just sorry, I'm Michael from Arbitration Place, just to let everyone know.
Right.
And again, too, so our panel will be going from about 3:30 till 4:30, correct?
Yeah, exactly.
Okay, perfect. And we do have to open up the rooms at 4:30 for I think the meet and greet. So if we are able to finish right at 4:30, I know it's everyone wants to get in everything they want to say, but just if we can maybe try and go for 4:29.
Okay. I have already told our panelists that we should be strict about keeping to time, so we will try and do so.
You can just mute us. I think that's the way now.
It's the Trump theory, right?
Can I just check a couple of pronunciations? Nilufer, how do I pronounce your name properly, please?
Oh, you did it fine.
Yeah, okay.
That's just fine. You said it very nice.
Nilufer Oral, is that right? Or
Nilufer, yeah. Well, the actual pronunciation is Nilufer, but I'm so used to Nilufer, it's good for me.
And oral, right?
Oral, yeah. Oral.
Okay. And I'm afraid, Ambassador Tao, I'm not going to be able to pronounce your name without a little bit more assistance.
Yes, it's correct. Yes, Tao is Thao.
And what about your first names? How would I pronounce those?
My first name is Nguyen, but in Vietnam, my first name is Nguyen. Nguyen. Yeah.
Nguyen. Okay. Okay, thank you.
Okay, thank you.
And is it right that you're in Hanoi at the moment? So
Yes. I am
an
in
hour for
Hanoi
you.
now. Yeah. It is the morning in Hanoi now.
What time is it?
2 a.m.
Oh,
Yeah.
well, thank you.
Okay.
Oh, goodness. That's very impressive.
So I think we have quite a good structure to it. And I think if we all try and keep to time as much as possible, we have a question at the end, which if we are running over, I won't ask about the international bodies, I think. But, you know, if possible, it would be good to have some Q&A, but obviously it will depend on the timings and things. But yeah, I'm quite excited about this panel. I think it's going to be a really interesting one. And it's great that we've got such a great panel as well. So thank you all.
Oh, yeah.
Very nice to be on.
No, thanks so much, Aimee-Jane, for coordinating us all across the world. It's wonderful.
Well, one of the advantages. Sorry, go on, David.
No, all I was going to say was thank you again. As I'm not a member of the American branch, I'm a UK member, so it's $100 to join this. So I was glad you got us in without having to pay.
I think it would be a little bit harsh to make you pay to join to speak on a panel.
Yeah.
But yeah, I know that. I think when it's done in person, they obviously you don't pay to speak on your panel, but it doesn't give you free rein to go to the other the other sessions. I suppose it is a bit of a money-making event for them. I don't know, frankly, how profitable or not it is in this new era. I think we are one of the earliest panels on the program.
Well, it's 2 days, is it? So it's this afternoon, then all day tomorrow, and all Saturday as well.
I'm not sure if it's all Saturday, but I think they've had the keynote, and then I think this is the first panel, actually.
Yeah, I think so too. They have kind of the opening panel. This is, and then we're one. There are parallel panels, aren't there?
Yeah, I mean, there's a lot of panels that they host, sort of 4 or 5 at any one time, I think.
Yeah.
Just a slight warning, I'm having a new security system put in, you know, a bit more up to date than the existing one, burglar alarms, and he set it off by accident 2 times already today. So if anything happens, I'll just mute, but I hope it doesn't. I did specifically say, please don't test it in the next hour. So, but if it makes you hear strange noises from my end, I'll try and mute. But if I'm speaking, it'll be
fair warning.
Yeah.
So the advantage of the current situation is that I think, you know, we've got a great panel, and in part because people are more available to speak when it's just a question of logging on rather than getting themselves to New York. The downside is that it's, you know, because everybody's all over the place, it's more difficult to coordinate in advance because we can't, you know, have multiple calls and things to set it up. But hopefully I think it should go quite well.
Yeah, and there are certainly advantages to this, but on the other hand, we certainly miss the physical interaction, talking to people over a glass of wine, chit-chatting, you know, those things. Once we start these and then they're over and that's it, we all disappear into our, you know, virtual land. But without this, it would be very difficult.
Can I just check? Do you want us to turn the cameras off as well, or just mute, or cameras off?
Okay, just so that we're just getting started here now. It's totally up to you on how the panelist wants to operate. All the attendees are here. Looks like the attendees are just rolling in right now, so they'll be able to see the screens right now. it's up to you on how you want the panelists to roll. If all of the panelists want to turn off their videos until they speak, they can or be on screen the whole time and just mute. I think that probably is the most effective way. And Mr. Freestone, if you'd like, I can pull down the share screen and you can put your screen up now because it's 1 minute.
Brilliant. Okay, thank you.
Okay.
No problem. And I will be in the background for anyone who needs assistance, okay?
Okay, so it's doing a bit slowly. There it is, right.
And at 3:30, you may begin.
Yeah,
So, go on.
The attendees should be able to hear us. We have about 24 on the line right now, plus the six panelists.
Great. I think we have 1 minute to go and then I will start promptly.
Perfect. I'll be in the background if you need any assistance, okay?
Thank you.
Yeah, thanks so much.
Okay, I'm going to start the session today very promptly because we are incredibly constrained for time. Welcome everyone and thank you for joining this ILW session on climate change and law of the sea. My name is Aimee-Jane Lee and I'll be your moderator for the next hour. Before we get started, I'd just like to take a couple of minutes to set the stage and introduce our distinguished speakers. The topic we're discussing today is how the law of the sea does and should respond to the multiple and profound challenges that climate change has created for the marine environment, including rising sea levels. And given that the UN Convention on the Law of the Sea, UNCLOS, was established in 1982, so well before scientific consensus, such as it is, on the reality and effects of climate change, there are efforts now underway to discuss how to update the legal framework on the world's oceans to confront the present realities. So states, the International Bar Association, the International Law Association, and the International Law Commission are amongst those considering how the law of the sea and international law in general should respond to the effects of climate change. One of the essential realities at the core of many of these challenges is sea level rise. Since the turn of the 20th century, they've risen by about 0.2 meters, and they're anticipated to rise by much more in the years ahead. So as we shall discuss, the changes to the geographic reality of the world's coastlines present a host of challenges for the law of the sea. And from there, the questions are broader still, including issues of statehood of submerged island states, protection of the marine environment, rights of persons displaced due to sea level rise, and state responsibility for climate change. How should international law respond to these challenges? So we have a fantastic lineup of panelists, all of whom are truly at the vanguard of the most important international law and policy-making bodies related to the law of the sea and climate change. I'll introduce them very briefly. We have Professor David Freestone from George Washington University, Rapporteur of the International Law Association Committee on International Law and Sea Level Rise. We have Dr. Nilüfer Oral, Director of Centre for International Law at the National University of Singapore, and co-chair of the International Law Commission on the study group on sea level rise in international law. We have Ambassador Tao of the Diplomatic Academy of Vietnam and the National University of Hanoi, and a member of the International Law Commission. And he gets a special thanks for being up at 2 a.m. in Hanoi to present today. And we have Nicholas Swan of Chapman Tripp in New Zealand, a current member of the IBA's Environmental, Social and Governance Arbitration Committee, and previously Secretary to the IBA Presidential Task Force on Climate Change justice and human rights. But there is so much to cover today and so little time. We shall, if possible, have time for a Q&A at the end. So please feel free to suggest questions in the chat function, including to whom they're directed, and I shall try to pick them up if we have time at the end. But without further ado, let's begin. So I think we're going to start with a discussion about baselines and delimitation. And David, I'm going to ask you perhaps to set the scene for us and consider and discuss for us what are the legal implications of the physical changes to different types of baselines established under UNCLOS as a result of sea level rise.
Okay, thank you very much, Aimee-Jane. Very nice, and thanks to the American branch of the ILA for inviting us. Great pleasure to be here, and to the audience. Thanks for being here. So I think you perhaps overestimated the amount of sea level rise, unless I didn't hear you correctly. But we have it's been pretty since the mid part of last century. We've seen about 20 centimeters of change generally globally. I think you said maybe you exaggerated in your presentation, but the Intergovernmental Panel on Climate Change, which I think now represents, the overwhelming consensus of scientists. You mentioned controversy about it. I think that's political, most of it nonsense. The scientists are pretty agreed on this. They've been working on this. The first IPCC report was in 1990. They actually predicted by 2100 a sea level rise of about 98 centimeters or a meter above current levels then. Since then, they've adjusted down and back up. And the last one in 2013-14 actually suggests 1 meter, pretty well 1 meter, that's 1 meter plus 10 centimeters now in the 2019 report, which is on the oceans and cryosphere, of which there is a very large area of doubt because of the melting of the polar ice caps. So what I'm going to do is a sort of 101, for those of you, it's a long time since you did your Law of the Sea. I mean, just to do a little recap, remember these are the zones which the Law of the Sea Convention permits. So acting from a baseline, which is the baseline for the territorial sea, but the other zones as well. Everything to the landward side of that is internal waters. States are allowed to claim, as the hydrographers tell me, capital M is nautical mile symbol. 12 nautical miles, you can claim a 12 nautical mile contiguous zone, EZ up to 200, and a continental shelf, which can extend to the edge of the actual physical continental shelf. So with the extended shelf beyond 200, where the coastal state owns the seabed and the resources, but the subjacent waters are high seas, and above that, high seas, and of course the area. So what are the impacts of this? So I've got a few graphics, and my thanks particularly to my colleague, Professor Clive Schofield, and his Dr. Asana, who've done most of these graphics for us for the ILA committee, which I think sort of demonstrates some of these impacts quite well. So here we have a nice tropical beach and the sea is coming in. And as it comes in, obviously with a traditional doctrine of ambulatory baselines, and that, again, we can talk about that if there's time, but the overwhelming view of lawyers, of international lawyers, is that the customary law accepts that baselines move with the actual location of the coast, not with where they are on the maps, although Article 5, Article 5 of the Law of the Sea Convention is a little ambivalent in the way you can read it. So as sea levels come up, sea moves in, bases move towards landward, and of course that has impacts on the land systems as well. It's not all lateral. I mean, they're dynamic systems, so there will be some changes, but the basic agenda is that they will move inland. And here we have quite a good, again, example of a peninsula here, which is shrinking. As it shrinks, a couple of areas become left behind, the high areas, which become eligible to generate their own zones. So using the ARC system, there we have, and that's the area which you stand to lose. And if we are talking about loss of offshore islands, so this potentially could be kilometers rather than meters. So that could be quite substantial. An example, because I actually was asked to look at highlight particularly the position archipelagos, here's quite a good example. Now, the Kiribati, pronounced Kiribati, actually has 3 island groups. So this is the first one here. There's one over here, which is the Line Islands. The Phoenix Islands, which is actually a marine park, is actually, these are 3 separate archipelagos. So that means you can draw baselines around the archipelago, and measure your zones from there. Some problems moving this one. There you are, and that shows you what would happen to this if the Caroline Island actually was unable to sustain a baseline. Then that's the amount, the shaded area is the amount of EZ that they would lose as a result. They'd still be entitled to EZ, but I've lost my archipelagics. I had an archipelagic map as well. I seem to have lost it. All right, but basically the archipelago, you draw a line around the outside of the islands, and you're allowed to include low tide elevations, which have small structures on them, and you basically measure your EZ from there. It's running a bit short of time. So if we look at this, if we talk about maintaining your baselines, one of the problems of this is as the sea rises, if you keep your baseline in the same place, your internal waters get bigger. So you look at it from a policy point of view, would you want to maintain your baselines or maintain your EZ? If you take the outer limit, then you've got an even worse sort of legal problem. As the sea rises, you actually end up with an exclusive economic zone, which could be wider than 200 miles. Either way, you have something of a problem. So the approach which has generally been taken by, I know we're going to hear about this later, by South Pacific island countries, is to say that they maintain all their marine entitlements. So that means, that does effectively mean that they extend their internal waters. So 5 minutes, stop there. Thank you.
Thank you very much, David. That was really helpful in terms of setting the scene, especially the slides. Having considered the impact on baselines, Nilofer, perhaps you could help us understand the legal implications for states' maritime boundaries with other states, given changes in the coastal baselines from which they're delimited. Nilofer, you're on mute. Perhaps you could.
Sorry. I was too eager to get my PowerPoint up. But first of all, thank you so much for this invitation. And I'm going to go, because I know we're short on time, so I go directly. I have a little PowerPoint as well on this question. While I don't have as fancy a PowerPoint as David does, I also will start with the maritime boundaries, which David very nicely explained. So the question then is, when we're talking about the situation of an ambulatory baseline, so it's sea level rise, if we take the scenario that the baseline will shift, and that is the landward shift. And so what does that mean in terms of the impact, the possible impact on maritime zones? And as we know, each maritime zone brings with it certain coastal state competences, regulatory competences, enforcement competences, and also third-party states have certain rights and obligations. And you realize that with the internal waters, the territorial sea, the exclusive economic zone, the coastal state will obviously have a legal framework in place. And all of this is, shall we say, takes a great deal of effort. And a lot of, and third-party states, of course, have also adjusted themselves accordingly. And if we look at the situation, if you have a landward shift of the baseline, and if that means that then you would have to shift the maritime zones, and that will depend on how much, and it could be significant, that means you have a situation where The internal waters could then become part of the territorial sea. Part of the territorial sea could become part of the exclusive economic zone, and part of the exclusive economic zone high seas. And these have very significant, could have very significant impact. And given the limited time, just to give you an idea, so internal waters, it's not really expressly provided for under the law of the Sea Convention, but it's understood that the coastal state has, complete sovereignty over this. That means that they can regulate the passage of foreign flag ships and activities in these waters. But if the internal waters become territorial sea, that means that you have a shift to innocent passage, and that would bring it under the law of the Sea Convention. And again, the coastal state has to respect the innocent passage rights of foreign ships. And of course, that brings with it certain responsibilities under Article 22. But I think more importantly is when we look at what happens with if the exclusive economic zone, part of it at least becomes part of the high seas, that's where we see a big change. There you have a different navigational regime in the sense that the complete freedom of the high seas, even though in theory it's supposed to apply to exclusive economic zone, we know that there is under Article 220, paragraph 5 and 6 of the law of the Sea Convention, the coastal state does have some competence to take some measures in the case of a serious oil spill under that provision. But more important is that the loss of the exclusive sovereignty rights of the coastal state to explore, exploit, manage, and conserve natural resources. So fisheries, assuming that we're not talking about an area that is under the regulation of a regional fisheries management organization, what was one then of the exclusive management and conservation of the coastal state, if it becomes part of the high seas, then it falls under the freedom of the high seas regime. Also, protection of the marine environment, one of the very important competence given to the coastal state, meaning that third-party states have to abide by the rules and regulations. But then if this becomes part of the high seas, that will change. And we know that there are increasingly marine protected areas that are being established also in exclusive economic zones. There are a number of them in the South Pacific seas. And so what would the impact be on those? So I only have 5 minutes. I don't know if I've gone over or not. I'm not able to time, but just very briefly, we can see that there could be very significant impacts on both the coastal state and also on third parties, states. So I'll stop right there.
Thank you, Nilufer. Ambassador Tao, having perhaps had covered for us by Dr. Oral the issues that arise in terms of relationships with third states and the loss of entitlements, perhaps you would be able to discuss how might a state defend its existing maritime entitlement, notwithstanding these physical changes which would ordinarily change its legal entitlement.
Yeah, thank you, Jane. Yeah, David and Oran talk before me about some option of maintaining maritime entitlement. So to defend exciting maritime entitlement in the situation of the sea level rise, state can choose one of 5 options. In my view, the first, it is a geoengineering measure. State can build a flood barrier, seawall, and any land reclamation work to fortify key base point, notwithstanding sea level rise. Singapore, for example, has a plan to expend $100 billion for this objective. However, this solution made a financial and technical burden to small countries. Land reclamation can be abused also to extend the maritime claim and change the nature of the coastline. And land reclamation activities can be regarded as an introduction by man directly or indirectly of substances or energy into marine environment and to harm marine environment. Those activity should be prohibited by the definition of the pollution in UNCLOS. Second option, it is to maintain exciting baseline defined in accordance with UNCLOS and maximum on a larger scale navigation and chart officially recognized by coastal state or through the list of geographical coordinated, notwithstanding physical change of coastline and impact of sea level rise. According to this approach, the claim baseline did not reflect reality, and maintaining baseline will be considered as a legal fiction and contrary to the global public interest in high sea and area. However, right and obligation of coastal state under the exciting law of the sea has been maintained. Third option is to maintain exciting defined outer limit of the maritime zone measured from the baseline established in accordance with the law of the sea and adjudicated by judicial body regardless any reject of the baseline or loss of the key base point impacted by sea level rise. According to this approach, the baseline can move landward in ambulatory manner to ensure navigation and safety. The breadth of maritime zone will increase principally more than 12 nautical miles for the territorial sea and 200 nautical miles for the economic exclusive zone and continental respectively. However, right and obligation of coastal state under the exciting law of the sea have been maintained and stated don't need land reclamation work for keeping maritime entitlements. Fourth option is to maintain both maritime baseline and limits. Red option harmonize favorable and minimize adverse effects of the two above mentioned option. It has been based on the object and purpose of UNCLOS to preserve peace, security, stability, and certainty. And it facilitates also the minimum change to the exciting law of the sea as possible. This option has been affirmed by state practice. And we have also the last option is a continuation of statehood when the land submerged. Developing states that are most vulnerable to sea level rise have the right to require compensation from developed country and emerging economy responsible for climate change and sea level rise. And from the other view, it is also no land, no sea application. A state doesn't obtain the power of sea if its land territory does not exist. In other words, only state but not government in exile can claim maritime zone. Therefore, when the state ceases to exist maritime zone cease and may revert to global common interest or to claim to other states. So over time, maintaining navigational safety by updating the actual recession of coastline could become a concern to keep in mind. So that the question of statehood is very sensitive and need to be considered with caution. Future assessment should foresee a long-term solution, and state party to UNCLOS can call a conference to find a long-term solution to balance interest of vulnerable state and international community. Thank you.
Thank you very much. I think what you highlighted there is that there's various options and perhaps no easy answers. You touched on the idea of statehood, and I'd like to ask Nicola perhaps to discuss for us perhaps what happens in some of the more extreme situations. So the legal implications of an island becoming uninhabitable, and perhaps what implications that has for concepts such as statehood and sovereignty.
Thanks, Aimee-Jane, and thanks. It's a real pleasure to be here. I'm looking out at Wellington Harbour right now, and these issues are very focused on in the Pacific, where a lot of the countries that are calling for action around this around the world are from the Pacific. So it's an issue that New Zealand feels very strongly about. In terms of the legal implications of an island becoming uninhabitable, we've sort of seen advocacy from states like the Maldives, which conducted an underwater cabinet meeting in the run-up to the 2009 Conference of the Parties under the UNFCCC, making the point that islands are literally forecast to disappear. And it's important to sort of stand back and think about the process by which that will happen, rather than sort of just the end point, because that's important from an international law perspective as well. So from the sort of physical side of it, the issue is obviously the gradual salination of drinking water, the gradual salination of the soil, increased erosion and flooding. And this is going to lead to populations moving before the island becomes entirely uninhabitable in the sort of sense of an island disappearing. So there's a complex issue from an international law perspective, because you have this gradual movement. Ban Ki-moon famously had said, climate change affects us all, but does not affect us all equally. And this is one of the areas where this is just such an example of that. So if you stand back and look at it from an international law perspective, and this audience will be well aware of this, the 1933 Montevideo Convention on the Rights and Duties of States is the usual starting point for what gives a state its statehood on the international plane. And that has four criteria which were not designed with a situation like a disappearing island state in mind. So a permanent population, so a non-transitory population, a defined territory, a government over that territory, and the capacity to enter into relations with other states. Those are the traditional criteria under Montevideo. And you can see immediately that the defined territory and the permanent population are points that could be seriously threatened by an island which population is having to move because of sea level rise. So the conservative view sort of on the traditional international law platform is that sunken islands would risk losing their statehood entirely, which is obviously a really concerning thing, and a very real concern for islands like Kiribati in the Pacific. But it's important to sort of stand back and look at the shades of grey on this. So again, people will be moving before the state as such is entirely disappearing. So we're likely to see this sort of concept of states in exile rather than states becoming entirely stateless overnight. There's historical precedent for that, allowing states to continue. You had governments of various countries operating from London during World War II, for example. And we've seen lots of calls by either the islands themselves or other countries nearby in terms of signalling purchasing of land for populations to move to, or I think it was Fiji that indicated it would lease a whole lot of land for one of the other islands to be able to move to. So there's going to be a practical impact that we see start to happen perhaps before the sort of hard-edged international law kicks in. So what we're going to have to confront as international lawyers is, can we look at international law as being interpreted from a more dynamic perspective, looking at treaties being interpreted in light of their object and purpose. Is there a way that international law can move to deal with this emerging problem? And there have been various arguments put forward, and I won't go through them all now because of time, but one of them, for example, is that if there has been a fundamental breach of jus cogens in terms of fundamental international law norms, then international law would require that would prevent statelessness from being a sort of a consequence of that. So if a state disappears because of climate change, this thereby violates the right to self-determination recognised under international law, then the argument is that this would place a legal duty on other states to continue to recognise those states, as opposed to trying to invoke arguments of statelessness. So there are sort of various arguments that can be made. There's the classic pacta sunt servanda, in that a state needs to comply with its obligations in good faith, and there's an argument that trying to deny a sunken island's obligations under a treaty would go very much against the grain of states complying with their obligations in good faith. There are arguments around using the international law principle of fundamental change in circumstances, which is similar to the frustration doctrine that you recognise in common law, to say, well, look, this has been a serious change of circumstances that no one anticipated. So there's going to be a lot of discussion around, how can international law move to prevent what would otherwise be a very black and white sort of risk of states becoming considered not states anymore under the traditional criteria. I think it's an opportunity for development of customary international law, and that's why it's so interesting to hear Ambassador Tao's comments in terms of state practice and state intention. And we're going to see, we already are seeing states very actively conscious of that development of customary international law and taking action to start to demonstrate some of that state practice.
Thanks, Nicola. As you say, it's definitely an area where there's an opportunity for dynamism and evolution of the law to adapt to these circumstances, which are really rather extraordinary. You touched upon, I think, this idea that it was a gradual change, and in the context of that, the idea that it would be not an overnight transition to a sunken island, but that people would be moving away. And this sort of takes us to the idea of persons displaced by climate change. And maybe, David, you could speak first to this in terms of how this is currently dealt with under international law, how issues of persons displaced by climate change from sea level rise are dealt with under international law.
Right, thanks very much, Aimee-Jane. So yes, first of all, I don't claim to be an expert on this. I'm co-rapporteur of the ILA committee, and I deal with the law of the sea parts of general international law bits. And my former co-rapporteur was Professor Jane McAdam from the University of New South Wales, who is a real expert on this. And she and Walter Kalin have been working with the Nansen initiative, actually produced as part of our report in 2019, which we all reviewed, but which they basically drafted, the Sydney Declaration on the Rights of Displaced People. And the first point that I actually made rather strongly to Aimee-Jane when we first put is they're not refugees, right? The word term climate refugees has been around for some time, and it's wrong. Even the UN Office of Refugees has said, please stop using this term. It's not correct. I'll read you the definition of a refugee, which is a person who, owing to well-founded fear of being persecuted for reasons of race, nationality, religion, membership of a particular social group or political opinion, is outside the country and owing protection. So it's all only on the grounds of persecution. So they're not refugees, they're migrants, but they are, I think the politically correct term now is human mobility, climate displaced persons, or human mobility in the context of climate change. So it's a very real problem, and I think Nicola already pointed out this is already beginning to happen, right? Some states are making arrangements to have other places of refuge to go to. So basically, the sort of three scenarios we see are, I think the first is the idea of instant displacement, if you like, immediate displacement, which is sea level rise is a slow onset event, but it's going to be punctuated by sharp events, right? So that would be a storm, which would cause a much larger incoming tide than normal, not necessarily tsunami, but extremely high tides, which would actually displace people immediately, and that displacement usually takes place within the country. For example, we've been talking about Kiribati. Well, Tarawa, which is the capital of Kiribati, is almost uninhabitable because the population is so big, because lots of the people from the small islands outside have come to live on the main island of Tarawa. There's the lure of urbanization, but it's also because it's slightly higher than some of the other little islands. So that's displacement, and it gets to a certain point where that has reached capacity. People are going to move outside, and we're seeing that, in fact, even during the time of the colonial period, large numbers of Kiribati, now then called the Gilbert Islands, were actually moved to live in the Solomon Islands, in Guadalcanal and the Solomon Islands. There's a settlement there, White River in Guadalcanal, which has been there for 30, 40 years, 40, 50 years. So it's an ongoing problem. And there is quite a lot of mobility between islands. So there's instant displacement, if you like. Then the event passes, and then you have to think about how you're going to adapt. And basically the message which has come, and I mentioned the Nansen Initiative, but the Nansen Initiative was actually discussing this problem with governments and with individuals affected, and then with the islands, to actually develop some guidelines, best practices and principles. And it's quite clear that people want to stay. I mean, it's a question of attachment to the lands which have been there, linked by heredity, by their ancient customary rights, tribal ownership, clan rights, which they exercise. Their ancestors are buried there. They want to stay there. And that's the best solution, in situ adaptation. And that might mean the sort of things that Ambassador Tone was saying. That's things like building walls to the extent you can, maybe even elevation. But we're talking very expensive, but it is possible. The Maldives have actually built a new island close to Male, Hulu Male, which is 3 meters above sea level rise, which is already the highest place in the Maldives. So that's quite an important sort of option, but it's very expensive. So if you think in terms of in situ adaptation being the best option, a lot of people will move. I mean, as this happens in areas, so migration is part of this. So back to the legal framework, there is already a framework for migration. Countries accept certain numbers of migrants. They have to accept that they're going to have to work, so that all the legal paraphernalia of work permits, etc., is engaged when a person moves from one country to another. And that's where a regional framework is going to be quite important for implementing, recognizing that some people will want to move, but not everybody will. And then we come to the next step, where Nicola had cast it rather well as an incremental effect. You know, you're going to get waves coming in, then you're going to get desalination of your water sources, and then eventually you won't be able to grow crops. Everything has to be imported, and it just becomes untenable. And that's the last step, if you like. So there's internal displacement, then there's migration, which is going to be part of this, which will be a smaller process. And then we actually have to look at relocation. And that is really, I think everybody would say this would be a last step. So there is a legal framework for that. A lot of the big development banks have had to do relocation projects in the past. So there's a very cleanly developed framework, if you like, of legal principles to apply this. People should not be worse off as a result of a planned relocation. And there comes a point where they may not be voluntary, but they should be voluntary in all cases. So the human rights framework applies. That's the normal thing. I'm sure that Nicola's going to tell us about that in a minute too, in relation to some of the domestic cases. There have been frameworks developed. So Nansen Initiative laid out some good best practices. The UN's General Assembly approved what's called the Stand-I framework, which actually sets out the relevant human rights principles which should apply to this. And of course, the human rights principles, the obligations are actually on the host countries to respect them, the countries where, the countries from which the individuals come, but also the countries to which they move. That's what I mean by the host countries. So there will be, those principles will apply. They're there, but it's the The challenge, if you like, is implementation, making sure that with this whole unprecedented operation could be handled in a sensitive and culturally sensitive way, and that disadvantaged groups, particularly children, women and children, if you like, but also small minority groups within countries don't suffer adversely as a result. So the human rights framework seems to be okay. It's fragmented, and just in the same way we have the fragmented framework of different sorts of rights, we also have a lot of initiatives. So some have come from the UN. There is even a task force established by the Framework Convention on Climate Change under the loss and damage, the Warsaw mechanism on loss and damage, to look at the question of assisting with costings of that. So there's quite a lot of initiative. I think people understand the issues, but it's an unprecedented issue, because we've been dealing with real refugees and we're dealing with migrants for a long time, and it's a problem particularly we've seen in the Mediterranean, but this is brought on by a physical change of this kind is really unprecedented.
Thanks, David. As you say, it's fragmented at the moment, and it will be a challenge to draw it all together. Nicola, perhaps you could have a consider for us how domestic courts have dealt with this issue.
Yeah, sure, Aimee-Jane. So really interesting challenge for domestic courts, and what we've seen is domestic courts generally being constrained by the same problems we see at international law, and that's the problem David pointed out, which is under the UN Refugee Convention. There's a very clear definition of refugee, which is the fear of being persecuted for reasons of race, religion, nationality, membership of a particular group, etc. And it doesn't leave a lot of wriggle room for impacts from environmental change. The issue has been looked at in domestic courts. A number of individuals have tried to cite the UN Refugee Convention as being the basis for why they should be granted refugee status in domestic courts. But again and again, domestic courts are saying that they are constrained by that sort of fairly black and white definition under the UN Refugee Convention, which obviously wasn't, when it was put together, intended to cover persons displaced by climate change. So, for example, a lot of the decisions have come from Australia and New Zealand, and that makes sense in a way, because you're seeing the impact of people from the Pacific who are applying to Australia and New Zealand because of the close relationship that the Pacific countries have with those two countries. So in 2009, the Australian Refugee Tribunal had to deal exactly with an individual from Kiribati who argued that he was fearful of returning to Kiribati because of the very issues that David has been speaking about, and the Australian Tribunal said no, they were constrained by that definition of refugee. Similar findings in New Zealand. The New Zealand Immigration and Protection Tribunal had dealt with a Tuvalu citizen who was making a similar claim. He actually applied under humanitarian grounds, and it was rejected as well on that basis. That the tribunal said there must be exceptional circumstances of a humanitarian nature such that it would be unduly harsh to deport the individual, and they found that the climate change angle just at that point was not seen as sufficient to justify that. So not just on the sort of refugee convention type argument, but on a broader humanitarian argument. And that's the interesting area that we'll sort of take a little bit of a look at, because that is an area where we may see some changes. So one of the sort of most senior courts that has looked at this issue most recently was the New Zealand Supreme Court in 2015, and there they were determining another individual from Kiribati, Mr. Tai Teota, who had applied for refugee or protected person status due to the impacts of climate change on Kiribati. Again, the sort of initial tribunal had rejected that claim, and it had worked its way right up through the appeal system to the New Zealand Supreme Court. But the court refused leave on the basis that there was no serious harm at the time if he was returned to Kiribati. But interestingly, the court did suggest that environmental degradation from climate change might yet create a pathway into the Refugee Convention or into other areas of international law. So it didn't rule it out, but it said at this time that just can't be sustained. So what Mr. Taitiota then did is he went to the UN Human Rights Committee, and this decision from the views of the Human Rights Committee was published just earlier this year, and it has had a lot of airtime because it was a fairly significant statement from the UN Human Rights Committee. So this was the Human Rights Committee is set up under the first optional protocol to the ICCPR, and it allows individuals to bring claims against states for violations of the ICCPR, the International Covenant on Civil and Political Rights. And there, Mr. Taitiota was alleging a breach of his right to life under the ICCPR. He went through the process that had happened in the domestic courts of New Zealand, and you have to exhaust domestic remedies, which he had done. And the issue was around whether the risk of violation of the right was imminent, because that is the standard that needs to be met in this context. And the committee held that environmental degradation from climate change can breach the right to life. So they could envisage that a climate change impact could impact on the right to life. In fact, there's a number of very serious statements they made around how significant this could be in the decision, and that this could trigger non-refoulement obligations under UN under international law. But strikingly, even though they had evidence that in 10 to 15 years, Kiribati could be rendered uninhabitable because of sea level rise, they still decided that at the moment there was time for intervening acts, either by the government of Kiribati or by the international community to take sufficient action such that the risk was not sufficiently imminent to sort of trigger them to find a breach of the right for Mr. Taitiota. So a difficult outcome for him, but a really significant step in terms of international acceptance of climate change potentially starting to trigger these breaches of international obligations. And I think that's the interesting part, is how these statements in international law are going to start to impact on these domestic court decisions, whether, even if they can't get through under the sort of strict UN Refugee Convention grounds, whether these types of statements around breaches of other human rights conventions could then open the door to individuals succeeding on humanitarian grounds before domestic tribunals. So I think that a decision earlier this year in Taitiota from the UN Human Rights Committee will be cited extensively by individuals that are now starting to make these claims to domestic tribunals.
It will be interesting to see when we hit that point, when there is sufficient harm or risk of harm that it meets the criteria, because as you say, even with proof that it's really pretty imminent in relative terms, it doesn't yet seem to be meeting the threshold. I wanted to switch the conversation slightly, and perhaps, Nilufer, you could talk to us a little bit with an analysis of how international environmental law and the law of the sea are addressing climate change, or not, as the case may be.
Thank you, Nicola. Yes, well, it's a very, very big question for 5 minutes. So what I will focus on a little bit, because these are, issues that one can spend much more time on. But one of the challenges, and you said it early in the opening, when the Law of the Sea Convention was negotiated and adopted, climate change was not on the radar. And it really didn't come up until, actually it was Malta again, raising it in 1988, I believe, the possibility of a climate threat. And the climate change, United Nations Framework Convention on Climate Change was adopted in 1992, along with during one of the important outputs of the Rio conference. So you have one convention, the Law of the Sea Convention, which is often described as the Constitution for the ocean, but it didn't take into account climate change issues. And it's not just sea level rise. The impact of climate change on the ocean, we're learning more about it. Sea level rise is one, thermal expansion, glacier melting, but also ocean acidification. We're learning more about that. And one of the challenges with ocean acidification, for example, is that it is exclusively the consequence of the ocean absorbing carbon dioxide. And because of the excessive carbon dioxide that our human activities are generating, the ocean in millions of years for the first time is changed its pH balance. And that has an impact on the environment. And there's also ocean deoxygenation, change of chemistry. We know what's happening with coral reefs. So many impacts on the ocean. But then we have the climate change regime that was specifically negotiated and adopted for climate change. But even though there's mention of the ocean and marine ecosystems, it's in a limited way. It's more looking at the ocean as a sink or reservoir, mitigation purposes, but it's not, the objective is not to protect the ocean per se from ocean acidification, sea level rise, all these issues that we've been talking about right now. So there's a bit of a challenge in bridging these different regimes. Where are we going to take action? For example, when we talk about sea level rise, indeed, the Law of the Sea Convention is an obvious point to start with for questions of baselines, but how will we do that? Because the Law of the Sea Convention doesn't have the same decision-making mechanisms that we see under the UNFCCC, where you have conference of the parties, you have expert bodies that can actually perhaps take some action. David mentioned, I think, some frameworks that are being developed. So the challenge now that's starting a little bit to move forward is to bridge these two regimes and how international law can fit into that. It shouldn't be that we should be treating, because ultimately climate change is a land-based activity. And the Law of the Sea Convention does address pollution from sources of land-based, and we can look at carbon dioxide as a pollution as well. But there has to be coordination at some level to address these issues. So I'll stop there, but I just wanted to highlight that there is a gap in the sense, and perhaps we need to be bridging that gap. So thank you very much.
Thank you. I think, as you say, you have these different regimes, and what you would hope is that they might overlap, and instead it seems that there's actually a gap instead between them. Turning perhaps a bit from the law to the policy side of it, Ambassador Tao, I know that you've had quite a lot of input in relation to the policy of the Western Pacific states, and I was wondering if you could discuss that for us.
Yeah. Thank you. As you know, the Western Pacific region have the most states seriously affected by sea level rise in the world. Depending on the geographical profile in relation to sea level rise, countries in the Western Pacific can be classified into 4 groups: small island developing states, low-lying coastal countries, big archipelagic states, and remaining states. Due to the different geographic profile and the impact of sea level rise, each group of states undertaken its own response to sea level rise. So concern with sea level rise is not unique in the region. The first policy is to approve a joint action plan on climate change and disaster risk management, including sea level rise. Tonga developed it in 2010, Vietnam in 2011, and Bangladesh in 2005. The policy focused on disaster displacement, information about the future threat, building flood barrier, and relocating facilities and people to higher elevation. Indonesia has a plan to move its capital from Jakarta to another place. Maldives built an artificial island which were 3 meters above the sea level near the capital Mail. However, you know that geoengineering solution, including land reclamation work to consolidate the exciting base point, are not the best option for poor and vulnerable state whose economic and technical capacity are limited. A small island state country encourage a 3-step policy to cope with sea level rise. First is a fixed and deposit list of geographical coordinated of maritime baseline and limit. Second, conclude outstanding maritime boundaries as soon as possible. And 3, that maintain in perpetuity baseline and maritime boundary delineated in accordance with UNCLOS, notwithstanding sea level rise impact. Other states in the region are reluctant to change the baseline in adapting to sea level rise. The Philippines and Bangladesh amended strait baseline respectively in 2011 and 2015 for political and technical reasons, but not in response to the impact of the sea level rise. Myanmar replaced the Norman baseline along the coast of Coco and Propagat Island, declared in 1977 by strait baseline promulgated in the law amending the Territorial Sea and Maritime Zone in 2008 and 2017. No any state in the region has intention to modify maritime baseline and limit. You know that from the Western Pacific state practice, we can make some observation. But the subsequent practice of the Western Pacific state can evidence the understanding of the object and purpose of the UNCLOS. That is to preserve legal stability and security regardless of the impact of sea level rise. Second, states tend to use a strait baseline rather than Norman baseline in the context of sea level rise. And third, states in the region share a view on the permanency of maritime baseline and limit. Fourth point. And the last is the initiative of Pacific Island state supported by the acts or omission of other states should be a starting point to find an acceptable solution. Thank you very much.
Thank you. I think what you've highlighted there is that even within the region, there are differing impacts, and there's perhaps not a one-size-fits-all approach. And I think that's perhaps something that's come out through all of the discussion we've had today. And of course, that's a challenge for international law, when sometimes you are essentially trying to impose a one-size-fits-all approach onto a problem, when patently that doesn't work in this circumstance. We are very close to our allotted hour, so I'm afraid I don't think we have time for questions. I would like to thank all of our panelists for the very interesting discussion that we've had, though. It's, as I said, I think it's one of these areas of law where the challenges are so great at the moment, and there, as David had mentioned, there are so many initiatives that are being undertaken at the moment by various organizations and bodies. And I think has also been alluded to, the challenge will be coordinating those to get some kind of proper coordinated response to an issue which invokes so many different problems in terms of international law. I am now tasked with telling the audience that there are networking virtual rooms to break out into. Before we started this panel, we were having a discussion amongst ourselves that one of the things that is lost, unfortunately, in this environment is the opportunity to have a glass of wine at the end of a presentation. But in an opportunity to try and replicate that, there are networking virtual rooms that are hosted by the ABILA committees. And I think these are listed in the programs, and the appropriate links are given there. So there's rooms that are related to arms control and disarmament, international arbitration, international humanitarian law, international intellectual property, space law, law of the sea, which may interest some of the people in this audience, and women and international law. So please feel free to join those and perhaps discuss what you have heard at this panel. Thank you very much to the panelists again, and thank you, of course, to everybody for attending the session.
Thank you.
Thank you.
Thank you much. Thank you, everyone. I'll be opening up the Committee on Law of the Sea momentarily.
Thank you.
So this session will be ending now.
Thank you.